Attorney Smith, you're saying that they're going to give you a separate list of ones that they anticipate that they would?
Yes.
Okay. Attorney Agati?
Your Honor, that's not exactly what the state has agreed to. The state has certainly agreed to winnow down the list, and the state has agreed to be able to provide more of the witnesses that we know we're definitely going to call in our reasonable time frame. But the state is not obligated to tell the defendant anything about the witnesses he's going to call. The defendant should be put on notice. The state doesn't mind doing this as a courtesy, but the state is not going to be ordered to do so. So we are happy to winnow down that list for the jury, and we are also happy to express to defense counsel some of the witnesses we definitely know we are calling. I'm not going to be providing the defendant with a trial plan of which witnesses are going to be called on which days in advance. If we come to a gentle person's agreement, as we always have in the past, Attorney Smith and I have always had this in the past, where we agree the day before testimony, usually about 5 o'clock the day before, who are the witnesses that the state is going to call. We will certainly be doing that. I look forward to doing that with them again. But with regards to providing what our trial plan is at this point, 3 weeks away, the state does not intend on doing that, nor does it have an obligation to do so.
All right. As I understand it, there's going to be that list of 50 to 55 that you would intend to call in expect to call in your case in chief. That list you are going to give to Attorney Smith. Is that accurate?
Yes, Your Honor. Not necessarily.
Okay.
We are.
Okay, and then Attorney Smith, the balance of their witness lists are witnesses that they may or may not call during the course of the trial, including for impeachment and rebuttal. That's how I understand it. I think that is adequate, and that you'll continue to work together to, where you can, give notice as to what are the upcoming witnesses so everybody can be as prepared as possible.
Yes, Your Honor.
Okay.
The conversation came up because, as you are aware, Attorney Brooks is a recent addition to the case. And with the almost 200 witnesses, we discussed the fact that preparation so far in advance would be quite scattered with that. So the state agreed to at least give us some inkling of those that were not expected to be called because they were essentially impeachment.
Okay, well, it sounds like that's everybody that's not on that, going to be on that 50 to 55 witness list, and I think that's adequate.
I agree. Either way is fine.
Okay, thank you. All right. There is no view. We do have a number of pending motions. I thought I was pretty much done with an order that was getting ready to go out. It looks like there's some responsive pleadings. As I said, I only had a very brief chance to look at what was filed over the weekend. So I don't know if that's going to change anything on my end. Some of them, the responsive pleadings were only due as of now, so I wouldn't have it. There were 2 that were outstanding. The other ones, I have to look to see whether there was a new responsive pleading where there had already been a motion of objection. In any event, depending on what these new filings are, I had expected to get you out an order on all of the other motions in limine this week, but I'll have to take a look at the new filings, but I will get orders out as quickly as I can. The motion to sever, I guess the question that I have on that is for the state, which is how quickly can you get a responsive pleading? I mean, it's definitely late in the sense that, I'm going to need to focus on what is this new evidence that suggests that now, after over a year of everybody thinking that it would be joined, that it should be severed.
Your Honor, you should have a responsive pleading. I filed one last night. It took me a few hours to write it up. We received their pleading shortly before 2 o'clock, I believe, yesterday afternoon. And I had a pleading that was, I submitted into the system, I think roughly around 10 o'clock last night to get one in. I think, Your Honor, that is worth another conversation once you've had a chance to review both of the pleadings. In short, I won't do the whole argument right now, but we put forward that the information that's disclosed is not new information with regards to what the allegations are. It's been provided in discovery sometimes 14, sometimes 22 months ago. That being said, if the defendant is now reassessing his desire to have a motion to join, which is what he wanted before, which is what we've been planning on this entire time, if he wants to readdress that, I think he has the right to readdress that, and that the court should look at the factors that are enumerated in Brown as to whether or not joinder or severance are the proper thing in this case. The state is asserting that it is based upon those factors. I think we really take umbrage with the idea that this is new information with regards to the motion to join, but whether or not the defendant has a right to withdraw his motion for joinder, I think that he does. And that I think that needs to be a longer conversation with the court over whether this matter should stay joined or whether it should be severed.
Well, I guess, part of the question I have, are we, in the event that and we can have a longer conversation about it. I don't even see the objection as in Attorney Ugadi. I don't know if it hasn't been processed yet or whether or not. You might just double check and make sure it was accepted.
I will, Your Honor. I filed it on both the CR 20 and the CR 577 matter.
Oh, not 577. 577 was the old case. It would be, and I'm looking at 2372.
I apologize, Your Honor. I filed it by 577 by accident. It is definitely in the 20 matter, the CR 20.
Okay. The filing issue is something that I also want to raise with everybody because at this point they've been joined, so I don't want to have to keep filing because there are objections in some and not in the other case. And my plan was to tell you to file everything in 2372, and I was going to issue an order saying it all applies to docket ending in 20. But now, if there's any chance of severance, I guess I don't want to say that. So, but like all the objections that I reviewed over the weekend were not in the docket ending in 20, but the motions were there, so it's gotten a little confused. So I guess we're going to need to deal with this issue of severance sooner than later. I guess, Attorney Smith, let me look to you. I'm going to look at these severance motions, but then if we change course at this late time, it doesn't, I don't know. I mean, I guess if there really is something that is so new, but I mean, that this is being filed now is somewhat concerning. Are we then looking at a whole new slew of limine motions on 404B and other issues?
No, I don't believe so, Your Honor. I think that
So you would just,
they can be severed. And as far as the 404B, I think that it is 404B wasn't filed by the state, noticed by the state, and
that's because you chose, everybody agreed to have these cases joined, so they would be part of the underlying conduct. So I don't know. I guess the 404B issue does become a live issue if they're severed, but if they were joined, it's not a 404B issue, right?
no, it's the other stuff that the state is seeking to do that caused us to file this motion to sever. And so we can be prepared for either to go forward as planned, but there has been a substantial change, or at least we have become aware of a strategy by the state that I believe would be unfair to Mr. Montgomery.
Okay, so let me just go back to my original question to you, which is, and I'm going to look at these, with a fresh eye, but I want to make sure that we're going forward as planned. There's not going to be an issue. So I just want to have a sense of what this looks like going forward. I will take a careful, fresh look at the motion to sever and the objection. Like I said, I haven't reviewed those, but in the event they were severed, is the only 404B issue whether or not the information from the second degree assault comes in, or does it now open an entire new can of worms around other issues?
I think I can let Attorney Brooks address that more specifically, but the state's response to our 404B was seeking to include a lot of 404B that is unrelated to the assault charge.
And that's aside from what you've already moved to exclude having to do with the bruises on Harmony that the state alleges Mr. Montgomery tried to cover up Harmony with the blanket so the police would not see her during the interaction, something other than that grouping of information?
Yes.
Okay. All right, I'm gonna have to review these motions and the motion and the objection. Because they were just filed, I just don't have a good enough sense of this to make a determination of where this will go on that issue. But either way, everybody would be ready to go forward in 2372, correct?
Yes, Your Honor.
Yes, Your Honor.
Oh, excuse me, Your Honor, just one quick thing.
Yeah.
With regards to 2372, I think the state and defense would be ready to go on either one of them. However, I think the assault charge is the one that needs to go first. He's been held on that 11 months longer than the other ones. And in addition, the state would then seek to use his conviction of that if he was found guilty, should he choose to testify in the following trial under 609, which it would not be able to do if we do the homicide first. So we would ask that the assault then be going forward if the defendant's choosing to separate these two. It's the first one that he was charged with, the first one that he's been held on for 11 months longer, and the first one chronologically that should be heard.
And Attorney Gotti, before you sit down,
Yes.
I heard you say we would pick both at the same time. Is that what I heard you say?
I think we could, Your Honor, depending on what you would like to do for scheduling. If you choose to sever this, then we would argue that the first thing that needs to go forward is the assault charge, because again, first one chronologically, the first one that he's been held on 11 months longer of incarceration as compared to the homicide charge. And it's the first one that occurs chronologically. If the court wished, with regards to, we've got this big chunk of time between February 6th and February 29th, then we could conceivably pick two separate juries. We could pick one for the assault and then a separate one after those jurors left for the homicide charge. We do the assault trial, we have a day or two or maybe 3 in between one trial to the next, and then we would roll into the homicide matter. The state is not saying that if you grant this motion to sever, that we are going to end up wasting our time in February and only doing 1 week. We do think that it's going to require a little bit of flexibility between the two. But the first charge that should go is the one that he's been held on the longest. And we think that we could still do that with one jury selection on the 9th. Or 6th.
And again, part of what I'm a little concerned about here, like I said, Attorney Smith, I'm going to look at the pleadings, but I'm just trying to get a sense of what all this would look like. In the event that they were severed, there isn't a bunch of pretrial litigation about, since that happened allegedly earlier in time, there's not going to be anything about the homicide trial that we would need to deal with for purposes of the second degree assault trial. We're not looking at a slew of new motions for that in the event they were severed. Is that accurate?
That is correct. And as far as the states choosing to pick 2 trials with 1 jury pool, I don't think that is could result in a fair juror, because it's sort of like having somebody charged with sexual assault against one person and sexual assault against the other, the second pick, the jurors are aware of the charge in the first pick.
Well, if you released if they were severed and you picked the second degree assault jury first, not telling anybody why they were here in the first place, then they were to leave and you pick the second pick, why would that be a problem?
If it's from a fresh panel, that's fine. But if it's the same panel, then the second pick is familiar with the charges in the first pick.
Right, but if we split them and we released, we had a smaller group that we chose from for the first trial, released all of those people, picked for the second trial, that would, you don't have any objection there, is that right?
Correct.
Okay. You'll recall in the gun trials, both parties felt that there needed to be, given how much publicity there was for this, that we needed to have a discussion about the homicide trial to make sure that they wouldn't be impacted. You recall that?
Yes.
Yes, Your Honor.
Okay, so Attorney Smith, I'm looking to you. Would you anticipate the same thing for the second degree assault trial?
No.
That you would not anticipate that we would say anything to them about whether or not they were familiar with the allegations?
If they know anything about the case, et cetera, then they would be asked. But given the responses in the gun case, no. I don't think we have to be so explicit anymore.
Attorney Agati, do you feel the same way?
Hard to say at this point, Your Honor. We know that we got quite a variety of responses when we had those potential jurors come to the bench last time out, and that was with an explicit warning. Might need a little bit more time to think about this one to give you a full answer, but I'm not too sure.
Okay. Okay. Like I said, I still have to read the motions. They've just come in.
And Your Honor, if you check in a moment, I have, just while we're sitting here, refiled that appropriately into the 2372 docket matter.
Okay, thank you. All right. So whether we need a hearing on that, I don't know yet. I guess keep an eye out for a request for the clerk for hearing dates and times in the event we do. All right, I note that there are somebody filed some special voir dire questions over the weekend as well. Have you had a chance to talk about that with each other?
No, Your Honor, we can do that after this hearing if you'd like.
Why was that filed so late?
I think because we were scrambling with the new information that we received and how it affected the case and other motions in limine and the like. As I said, Attorney Brooks is new on the case and we've been scrambling. And so we got the motions in limine out. We started investigating under the state's responses and we have moved as quickly as we could.
All right, Attorney Agati, if you would take a look at those and file, how quickly can you file a response to that?
Your Honor, we've got no problem with the defendant having filed this last night. I would like to just take a chance to look at it. We'll have a response for you later on tonight. We will get that filed in for you. That should not be a problem, especially when it comes to general voir dire. But again, the state does object to the idea that there's some sort of last minute discovery that's going on that has prompted all of this change. And you'll see that in the state's response to their motion to withdraw the motion to join.
Okay. But Attorney Gotti, your position is even if the information is not new, the court should take a fresh look at a motion to sever?
I think, Your Honor, that even if the information, well, since the information is not new, we feel that the defendant does have the right to withdraw his assent to the joinder, since it's before trial. If we were in the middle of picking a jury, I think that that would definitely be a different story. And we are far past the dispositive motion of December 15th. However, in the question, the law is still clear on joinder as to when a matter should or should not be joined under Rule 20. And under that, there are three separate categories where a matter can be joined. One of them is the last one, which is really the matter that defense briefs and that we brief as well, which is with regards to whether or not even though they're part of separate criminal episodes, they're nonetheless logically and factually connected in a manner that does not solely demonstrate the accused has a propensity to engage in criminal conduct. 5 factors of the Brown case, Your Honor, that determine that the court will look at. I know you're well familiar with that. Some of those factors do not support, other factors do. We have a disagreement about whether or not those factors do sufficiently represent joinder. So again, it is late in the game, but prior to jury selection, I do feel the defendant has the right to be able to withdraw his motion if he chooses to, and that the court will have to undertake this analysis and decide how to go forward. Granted, we differ on how the court should go forward, but I don't disagree that he has the right to do this.
All right, thank you. All right. So 1 moment. Okay. How long do you want for panel board, dear Attorney Smith?
I think 25 minutes to a half an hour.
All right, well, I guess it does depend on which case we're talking about, in the event that they're severed, which is why this is so problematic to be done at this late stage. This is, so I'll give you 15 minutes if it's the second degree assault, if they're joined, 25. Or if it's the homicide, 25. Does that sound okay to everybody?
Yes, Your Honor.
Thank you, Your Honor.
There are no scheduling issues during the period. No interpreters needed for anybody, for any witnesses, accurate?
There will be one interpreter, Your Honor, that's going to be needed for the state for one particular witness. We've been in the process of trying to consult with an agency to provide that. I don't have final dates and times yet, but we will need one Portuguese interpreter. Are you gonna make the arrangements for that, or do you need us to make the arrangements for that? Let's say, Your Honor, the state was in the process of making those arrangements for that.
Okay.
That being said, if you want to take one more thing off my plate, feel free. But
Not,
we don't.
I think given that you know who it is, where they are, when you expect them to testify, and you're in the process, you go ahead and do that. If there's some problem there, you'll let the court know, and we'll see if we can assist. How's that?
We do, Your Honor, and if there's a problem with that process, we'll let the court know at least a week ahead of time so that there's an ability to fix this. But I hopefully anticipate that we'll have an interpreter, no problem for this witness.
Okay. All right. So how many alternates do we want to choose? Again, now we're in this kind of dual track here. Assuming everything's going forward as it was, how many alternates do you think, Attorney Agati?
Your Honor, the state would propose, if we're only going ahead with the assault, then we would propose just 2 alternates. We think that would be sufficient. If we are keeping the matters joined, then I think that the court needs to consider 4 to 5, given the length of the trial. We're also going to be doing this over the month of February, which, based on the month of January, has not been great for people's health, it seems to be in the state. And separate from that, we also have to consider that in the jury selection process, we will be running into school vacation, but we'll also be running into President's Day, which I know is going to be a holiday, not only for the court, but then for other members of our jury pool. So I think as a result of that, we should consider 4 to 5 if we're doing the whole thing together.
And how many days, if the cases are severed, how many days do you think that will be?
If they're severed, Your Honor, I believe that The assault trial would be within a week. I think that we could get that accomplished in short order. And with regards to the homicide trial, I would anticipate that to be probably 3 to 3.5 weeks. So it puts us right at the end of our 29th deadline there. Granted, the homicide, of course, gets a little bit shorter if the assault is severed out of it. That will eliminate a small number of witnesses, but there are a lot of witnesses who are going to be repeated from one to the other, hence another reason for the joint.
We're gonna have we may have scheduling issues if you think you're gonna try the second degree, if we sever them, and you think you're gonna try the second degree assault and the homicide back to back, and one's gonna be a week and the other's gonna be 3.5 weeks, then we're at 4.5 weeks, and that is not what we scheduled. So that may be somewhat problematic.
I understand, Your Honor. I think the state can try to cut down. Again, we've been dealing with this for less than 24 hours for trying to figure out what the scheduling would look like. I think I'll have a better answer probably at the end of the day today with regards to how that trial schedule works out. I think we can do the assault trial relatively quickly. It may mean that we don't have time to really stop and breathe before we launch right into the next trial. If we're gonna keep it all in February.
Okay. Attorney Smith, do you want to comment on that? Do you agree that we're going to be able to get this all in the time allotted?
I would think to deliberations, yes.
Okay. All right. So, I'll think about the 4 to 5 alternates. I agree that we're going to need a significant number in the assault charge, just 2, in the event that they're severed. 3 peremptories each in either case. Everybody agrees to that?
Yeah, I think the preemptories, with extra alternates, you get an extra peremptory. So it would depend on if we had 6 alternates, at least 2 extra preemptories.
Well, the rule says 4, the statute says 3. So if I give you 4 peremptories each for 5 alternates, is that adequate, Attorney Smith?
I think we'll have to make do if that's what you order.
Okay. I'm just looking at my notes. Attorney Smith, do I have
So, Your Honor, I think Attorney Brooks has pulled out that rule, and it would be 4 to 6 alternates to preemptory challenges.
2 additional in 4 to 6?
Yes.
So if we end up with even 4 alternates, then you want 5 peremptories?
Yes.
Okay, and in the event that they're severed, it'll be 3 peremptories in the second degree assault. All right. Did you file your responsive pleading on the state's motion regarding what they titled as defendant self-serving statements?
Yes.
Okay, I'll have to look at that because that was not in as of this weekend. All right. Anything else we can accomplish today?
Your Honor, the state does have briefly some things, unless Carrie, you want to go first?
No, go ahead.
Okay. Just with regards to trying to determine what the, for witnesses and line up and being able to schedule them appropriately. what are the hours that the state should anticipate for trial every day? And I know that Your Honor, I believe still does some drug court obligations, so we want to make sure that we're scheduling appropriately around that.
So I was able to get, for the most part, coverage for, drug court. So we'll have drug court, but I won't be doing it. So, Clerk Scanlon, are you there?
Yes, Your Honor, I'm here.
Okay, so we are gonna go straight through on Tuesdays.
That's correct.
In terms of morning, the morning dockets, I believe that we are slated to go straight through starting at 9, that we did not put any 10 a.m. dockets on, but let me just take a quick look. I could be wrong about that. No, actually, Mike, can you tell, Clerk Scanlon, can you tell if there's any 10 a.m. dockets?
For the most part, there are not. I can go through, but for the most part, it will be a 9 a.m. start.
So we'll double check that so that we know for sure. I think in all likelihood, we'll be starting at 9. There may be a couple of days where we have to start at 10 due to a morning docket, but we'll let you know.
That's fine, Your Honor. About say 1 hour here or there is all right. We'll make sure that we have enough witnesses planned for each day to go for the full day from 9 through to 4.
Okay.
The next question that the state had was with regards to the jury pool and questionnaires and what the estimated timeline was for us to receive that. It takes us quite some time to be able to run criminal record checks. The state traditionally does that. We want to also be sure that we can get that done and provide that to defense counsel ahead of time. I just didn't know if we had an estimated time either from yourself or from Clerk Scanlon when those would be ready, and we'll start that process.
Was that the question?
The jury
I do not
questionnaires.
have that. Clerk Scanlon, do you know?
No, but I can find out relatively quickly, Your Honor. I can have that information for you, Ben.
We'll notify you. We'll notify both parties.
Thank you, Your Honor.
And Your Honor, from the just a review of all the dates, it looks like you have 9 a.m. start times throughout the trial.
Anything else?
One last thing, Your Honor. I know that we had discussed back in, I believe it was October, when we had talked about whether or not we were going to be doing a view. You had mentioned it at the beginning here that at the end of October, we decided at that time that we were not going to be doing a view. The state has just reassessed that recently, and we think we may need to get people on the bus for 2 quick stops. However, there's a more important part of that. So the first is that the state would make any arrangements for that view, and we would seek to go to the 77 Guilford Street address, and then as well as a drive through to the area of Colonial Village in Manchester, down to the Habit CPSC clinic and back. This would be essentially only one time that they would be getting off the bus at Guilford Street to remain outside the address, and the other one would simply be a drive. We would not necessarily be making stops at Colonial Village or at the clinic. However, defense counsel has addressed with us that they would like to arrange, or they would like the state to arrange that the Chrysler Sebring.
We can shortcut that. Since our conversation, we did not file for one because we're okay.
Oh, okay. So you don't want the Sebring brought to the courthouse?
Right.
Before.
Right.
Never mind, Your Honor. The second part has taken care of itself. I thought initially we were going to have a large car transported here. That's not going to be the case. So the state, you had brought up view at the very beginning. I didn't want to interrupt you, but the state is going to be seeking at this point to set that up. We would arrange for the bus and coordinate with the deputy sheriffs. It would be a stop at the Guilford Street address outside the home, and then a drive between 2 separate locations. That has been a change from before. Again, I didn't want to interrupt you before when you had brought it up. We had other things to discuss then.
And those second 2 stops, the jurors would be getting out?
Only one stop, Your Honor, and that would be at the Guilford Street home. The other would essentially be a drive-by. The buses would drive to that location. Jurors would stay on the bus. There's no need to readdress with them anything. Both sets of parties would have an opportunity to provide the preview statement ahead of time. There's nothing else to discuss with them. And then they would drive past another location in the city and then travel back here to the state, to the courthouse. So it would be one particular stop, not two. They would drive between the other areas.
And what do you anticipate? So you anticipate picking the jury, doing preview statements, going on the view, coming back and opening?
Yes, Your Honor. And that is with regards to the homicide charge. We do not anticipate a view if there's a severance for the assault charge. There would be no view there.
And so we're talking about, I would say, a little more than half a day for the whole, well, are we talking about a day by the time we do preview statements, get everybody on the bus, drive them around and come back?
Half a day, Your Honor. All of these locations are here within the city of Manchester and can be reached within minutes from the courthouse. I can think the last jury trial I did, that did involve quite a bit of travel between Hooksett and Manchester. That was a half day. It was a 2.5 hour long process. But
Okay.
I don't anticipate this taking anything more than a morning to get this process over with, and then we'd start up with trial in the afternoon.
And how long are you requesting for a preview statement?
10 minutes tops, Your Honor. I don't think more time is necessary than that.
Attorney Smith?
Your Honor, during my last homicide trial that involved a view, Judge Kissinger, I think actually we agreed that the opening statements were prior to the preview statement and the view. And it seemed to really assist the jurors in understanding why the view might be relevant at all. So I would suggest, I didn't know that the state was now going for a view, and I would simply suggest that we consider having the opening prior to, and then the preview statement would just fine tune, this is where we're going.
Yeah, I have done it both ways. I think, Attorney Agati, any objection to doing openings, and, you can actually incorporate your preview statement into your openings, and we could do it that way.
I see that argument, Your Honor. I see also the flip side of the coin, which is that in both opening statements, both sides are going to be talking about locations, and it makes sense for the jury to have seen those locations prior to hearing about them. Hence why a preview statement is so short, to be able to get them to have the visual memory, the visual evidence that they take in, to then be able to apply to opening statements. So the state still feels that a preview statement is better to be able to ingrain upon and impress upon the jurors what they're going to see, as compared to doing the opening statement, which has to be all encompassing of the charges, as compared to a preview statement, which is focused just on the two areas.
But what if I gave you the opportunity to do your opening statements, both sides to do their opening statements, and then do a short preview statement, and then go for the view? What do you think about that?
Again, I think the state, Your Honor, are you still
Are you
there?
there?
We've lost you on the screen.
Oh, I'm here.
Okay. Hold on just a moment.
Okay, I can see you and hear you
Okay, we got you back.
without interruption.
Thank you.
You cannot see me?
No, we can see you now. We got
Okay.
you back.
Okay.
I think, Your Honor, that the state's preference is for preview and then opening afterwards, but if the court wishes to do it the other way around, that's certainly the court's choice, and the state will make the appropriate plans, whatever you choose.
All right, thank you. I'm gonna give that some thought. Okay, so Attorney Gotti, is that it for your list of other issues?
I'm just going through my list now, Your Honor, if you could just have a brief moment. I think the only other thing to discuss, the last thing from the state, is with regards to A date, Your Honor, if we could talk with the court reporter after today to be able to talk about a date to pre-mark exhibits. I think that that's going to take a period of time. I know at the last trial, I think it worked out well where the state was able to, with defense, bring our exhibits in, have them marked. And so that made the process, I think, a little bit smoother. We'd like to be able to do that again. I imagine it would probably take a little bit over an hour to do so. Also, with regards to the homicide trial, there will be one larger exhibit that the court will have to accommodate, and that's a section of the ceiling drywall. We will be seeking to have that brought in. We can make arrangements with the court on the appropriate time to do so. But I think the pre-mark date is probably more important. If this is the assault trial, I think we can do it very, very quickly. If we are doing the assault and the homicide, I think we're going to need at least an hour, possibly two, for pre-mark. And we would
Okay.
like to be able to do that maybe at least just the Friday or the Thursday before jury selection at the latest.
Yes, I do. I require pre-marking, and that includes the parties having accomplished a meet and confer to determine what's marked for ID and what's marked as a full exhibit, so that we're not doing that in the middle of trial. I think it makes the trial go so much more smoothly. So any objection to that from the defense?
I generally do not agree to full in advance because once, but I can certainly let the state know that we won't be objecting to admission of evidence. But if it's marked full, then the evidence can actually come in through the wrong witness without the appropriate foundation and the like. And then we're in odd sorts of arguments during the course of trial. I do agree to exhibits and can let the court or the state know the ones that I would actually object to as being admitted at trial.
Well, let me suggest this to you, Attorney Smith. Sometimes there are exhibits that you both want to be admitted as full exhibits. And so there may be some things that you can agree on. Agree on what you can agree on, and what you can't agree on, those things will be marked for identification. That's all I mean by that.
Thank you.
Okay. So I would like you to do that at least 5 days before jury selection, okay?
Yes, Your Honor.
So please work with the court monitor to find a time to do that. I know this is definitely made more complicated by this late severance issue, but we'll have to deal with that one way or the other. So I'll have to, part of that will also depend on whether or not I can make a determination, how quickly I can make a decision on that. But I've got to read the pleadings first, so. All right, anything else from the state?
No, Your Honor, that's everything on our laundry list. Thank you.
All right, Attorney Smith, anything on your laundry list of things?
The only thing is that we were to have had a schedule on the 609 on Friday. I'm afraid it got filed on Saturday. And the state has provided us with the criminal records of witnesses. I advised the state that we could have the 609 motions filed by this coming Friday. I think that I'll be able to actually provide the state a list of witness records that we seek to introduce, but maybe not in motion form by Thursday, and then have the motion filed with you by Friday.
Okay. And the responsive pleading from the state?
I think, Your Honor, we can do that in short order after we see that pleading. I don't think that we're going to have a disagreement over too many of these, since I think the 609 is fairly straightforward as to what's allowed and what's not. Just for Your Honor's edification, though, I mean, there have been, with regards to the criminal background checks, just doing my count appropriately, 69 of them have already been provided. 6 are witnesses on our list who were private citizens are not going to be called, and I will tell the defense counsel after this who those are and update the court as well in our witness list. And then there's only 6 of them that are outstanding. 2 of them had dates of birth that needed to be confirmed, which were done over the weekend. One is one that we simply missed that had not been done, and one is one that we will still seek to get, which we do not have from this particular witness. I've asked Manchester Police to try to locate them and find out what their date of birth is. So in terms of what's outstanding for criminal records for the defense to review, we're literally talking about 6 names that we hope to have fixed by the end of the day.
Okay, so if I set a deadline for you to file a responsive pleading, if they file their 609 on Friday, you think you can file a responsive pleading by the following Wednesday, the 24th?
Yes, Your Honor, I think we definitely can.
Okay. Okay. So, Attorney Smith, what else did you have?
That was it for my list, Your Honor. Thank you.
Okay. All right, obviously the big issue here is going to be the severance issue. I'll review the pleadings and determine whether or not the court needs a hearing on that. And if the court does, I'll have unfortunately, I'm going into another trial period starting Monday. So I'll have the clerk reach out to you to see if we can schedule something quickly in the event that the court feels a hearing is necessary. Attorney Agati, do you want to?
Just briefly, Your Honor, the state certainly understands. The state believes that the court will be able to make a decision based upon the pleadings. But like you said, if you'd like to have a hearing, we're more than happy to be here for that. We are not requesting a hearing at this time. We think the issue is fairly straightforward.
All right. Your view on that, Attorney Smith?
I think I have not read the state's pleading, but to the extent that they have represented that it, at our request, is not inappropriate, that it is appropriate for severance if we make that request. It sounds like I don't, but I haven't read their pleading.
Okay.
As Attorney Brooks reminded me, there may be a need for documentary evidence to be provided depending on their response.
Why don't you elaborate on that, Attorney Smith? Are you suggesting that this Wicker information needs to be provided to the court?
Yes. Again, we said that the pleading was based on a strategy taken by the state, and we were provided January 10 or 11 a Zwicker letter from one of the state's main witnesses that had a substantial change in the evidence that led us to this point. And it may be that you need to have a copy of the Zwicker letters.
Well, why don't I suggest this, which is, when did you get those Zwicker letters?
Thursday would be the 10th or 11th. I recall getting it Thursday. They may have sent it Wednesday night. I'm not sure. There was another Zwicker letter that was dated December 26th that I think we got January 2nd. That had some concerning differences, but then the 11th was pretty much the straw.
Okay, but you put in your motion what it was that you think made this different. I mean, right? I assume that you put that into your motion already.
Yes.
Okay. I suppose if I need it, we'll reach out to you. If you want to file it by the end of the day.
Thank you.
Attorney Gotti, do you think it should just be filed?
Your Honor, I think it's up to the defendant whether or not he chooses to file that. That's fine. If so, then as the state points out in its objection, which you'll see, we'll be happy to file back the pages of discovery where this information was previously disclosed sometime as far as 22 months ago. So we don't mind doing that. We've referred to the bait stamps pages in our response, and we can also send over a copy of the emails when that discovery was provided, if the board would like. That being said, I think the defendant probably wants or counsel probably wants a chance to speak with their client and decide what he would like to file, and then we can file the appropriate response within a day.
If you think that needs to be provided by close of business today, Attorney Smith, in the event that they do that, Attorney Agati, and you feel the need to file the responsive documents, file those by the end of the day tomorrow. I mean, this is, obviously this significantly impacts everybody's trial preparation, and the court needs an opportunity to write an order, which I don't imagine is a margin order in this instance. So by the end of the day today, if anything additional from the defense, by the end of the day tomorrow, if there's anything additional from the state, okay?
Yes, Your Honor.
Thank you.
All right. All right. We will reach out to you if we need a further hearing. I may want to just, depending on how all that shakes out, I may want to see you just so that we're ready to go forward on the 6th as planned. So just the clerk will be in touch with you if we think we need another hearing, but otherwise it sounds like everybody's ready to go. Anything further from you, Attorney Smith?
No, Your Honor.
Anything further from the state?
No, Your Honor. Thank you.
All right, you're all set, everybody. Thank you so much.
Council, those questionnaires will be available, it should be on January 26th, about 10 days prior to selection.
January 26th. All right. Thank you.
All right, so it sounds like they'll be back January 26th. I intend to stream the trial the best that I can. I'll be on time, unlike today. I want to make sure that if I'm going to commit to, streaming it, that I'm on time so you guys can see everything. I really just want to make sure that I've got it up on my channel so I could go back and rewatch it. And I hate when I'm watching somewhere else and it gets removed, or they're talking during the trial, or maybe not talking and not giving content. Either way, I just want a copy for myself. So anyway, thanks for joining, and I hope you guys have a good day.